In this week's video, the 10 stages of estate planning, the 5 steps to take this summer with your wealth management advisor, and why you want McGowan Group Wealth Management on your side when you're gone.
Stay tuned.
It is summer planning season. The wealth managers at McGowan Group Wealth Management will be going through estate plan checklists. We're going to walk through in today's video the 10 stages of estate planning and why this is the team you want on your side when you're gone.
Yeah, over the past couple of decades, we've processed hundreds of estates. That would make us, pretty close to being experts on that.
Well, and your estate planning attorney, yes, he could process an estate, but if the assets are here, well, you've got whoever the custodian is, the wealth manager needs to know what the plan is.
That's right. And how do you start?
Well, let me give you a couple of things.
Okay.
All right. So as we go through this, there's your, disclosure. You need an estate planning attorney for the legal stuff.
That's right.
We coordinate with your estate planning attorney, and in the reviews, we'll send a recap to you and your attorney, including some of the recommendations, right? In our approach, the easy step is the beneficiary check.
That's right.
Most IRAs lack contingent beneficiaries, except for here.
Yeah, we do pretty extensive reviews on beneficiaries.
So usually it's all to spouse, and people forget the contingent beneficiaries, especially like on 401ks. But in the IRAs, if you don't have contingent beneficiaries and you're both gone, then it just creates the tax instantly and you've got a mess.
There's another important piece to that, and that's called, do you want a per stirpes designation?
Explain that.
Basically what that says, if your contingent beneficiary, call it your son or your daughter, passes away, then you want that to go to their bloodline, which would be their kids or your grandkids. That way it doesn't go to the spouse or somebody else.
Well, and if you don't, you could just skip it, go to the cute little grandbaby.
You could do that too.
No nuts and mopey.
There you go.
All right. Now, choosing an executor or trustee. This is tough, but we do have corporate trustees. Those fees have come down. It used to be a bank that would give you bad investment choices, and they would charge you like 2% if they were the trustee.
Well, it's still about 50 basis points. It's an extra cost. For larger trusts, that may make sense as you pass the assets along, but normally it's a trusted friend or family member.
Now, we include, at the client's request or discussion with the client, we include in a Zoom call the primary trustee.
When ready.
When ready, cover the account structure. You don't have to cover the dollars involved.
That's right.
If you don't want them to know yet, but they need to know who your wealth manager is, and you can put them on the subscription list just by sending us an email, networthradio.com or the McGowanGroup.com. Be sure that we've got your primary trustee included to start trustee boot camp, and we'll include them in our monthly newsletter.
There you go.
That's part of the process. All right. You want to start educating them, and they need to know what the structure is and who your investment team is.
They also need to know that they have a fiduciary standard to uphold also, and the best way to do that is through a living trust.
A fiduciary standard, do the right thing as if...
That's right.
Right. What would you do for yourself?
That's right.
Now, living trust, all right? Will versus living trust.
I like the living trust.
Right. So let me cover the process of a will versus you cover the living trust.
Okay.
All right. So I draft a will, right? I name an executor or trustee. All right.
Yep.
In this case, whoever that is, they have to go to the courthouse, file the will with the probate, get a letter of testamentary. This usually takes a couple of weeks.
At least.
Logistically to get done. And if you have an attorney do it, then you have to pay extra cost. Then the letter of testamentary says, okay, the executor's in charge,
Yep.
right? But if the will doesn't mention certain assets, then you kind of have a mess. Now, hopefully it says at the end, and everything else, this goes here. Well, that's a lengthy process. We have to open an estate account.
Mm-hmm.
Then the assets go there. The IRAs take care of themselves. They pass directly with the journal to the beneficiary IRAs. But if it's just taxable account, it has to go into the estate. So everything's disrupted. The banking pipes get shut off, right?
That's right.
If you were taking income, and you've got yourself more or less a process, as opposed to you cover the living trust. What happens if I have a living trust instead of
That's
a will?
right. So a living trust is basically creating a trust. It avoids probate completely.
Spouses are the trustees. It's like a joint account.
Right. The spouses are the trustees. Then you can have a successor trustee if you need to delegate some of those operations to.
Before you and I turn 105, we're going to start to forget stuff.
That's right.
And you don't want to be sitting in the dark because you forgot your light bill. So you can pass it to your successor trustee. And of course, powers of attorney work. Problem is, if they're more than 3 years old, it's hard to get people to take them.
That's right.
But
this is basically paying to do your probate up front. Everything passes smoothly. I've been through a living trust in my own family situation. Has worked very, very well.
And it has a pour over will. It says everything that wasn't in the trust at the time of the second to die is now in the trust.
That's right.
So they don't have, well, you've really saved your beneficiary executor quite a bit of headache. Your CPA, attorney, and wealth manager really need to be on the same page. And part of this is getting your wealth management team the copy of the trust or the will. Because if we don't have a copy, or if it's just simply saying somebody's the trustee,
Yeah.
but it doesn't tell us what to do, then we don't know what to do.
It's hard to help when you don't know how to help.
No, and the attorneys used to be really cagey about this, but our document vault has everybody's PDF, and we double check the document vault during summer planning season. And the reading of the will is trustee boot camp. You get whoever your trustee executor is, you go over the will with them and tell them what you want,
Yeah.
right? That's part of the checklist.
And make sure they understand. And one of the things we did is put together a list of responsibilities and roles that trustees must adhere to. It says, hey, you have a higher fiduciary responsibility than just a POA. I think one of the issues that we've seen with POAs, particularly in the news, is that a POA just says, well, I'll just take this money out.
Yeah,
And you
we
don't
had
want
one
that.
case. Okay, so this lady is like 95, this client.
Yeah.
And she has two sons, and she's 95, right?
Yeah.
And I said, well, you're starting to forget, because I have to send you an old school hard copy letter when we talk so you can remember. And I was just really frank with her. That's my job.
Right.
And I said, it's time for one of your sons to take over. And she said, oh, they're just not ready yet.
They're
And I
65
said,
years
yeah,
old.
how old are they? They're in their 60s. And sure enough, it became necessary that one of them stepped in. First thing he did was took out enough money to buy a house with his girlfriend.
Yeah.
So I guess she should have had a different trustee, right? And you could get a corporate trustee or something. But anyway, she was mad, right? She was really upset. So power of attorney, not always a good thing. And
It doesn't have that higher standard.
if a mom's still looking for signs of improvement in her middle-aged children, maybe you do need a corporate trustee for a little
That's
while.
right.
All right, charitable planning strategies. Go over the donor advised funds because a lot of our clients are using this.
Yeah, so the donor, it used to be that you could only put cash in donor advised funds. Now you can actually move assets into there. So the donor advised fund gives you a tax benefit the year that you put it in there. And then within 2 years, you have to start distributing 5% annually. But you get the deduction up front. And you can do it in a way that says, hey, these are the places that I want to get it. As long as it's a 501(c), you can make that right now in your highest tax years, make the contribution donor advised fund, and then decide later how you want to distribute it. So it's a great way to get a tax advantage in the year that you make that donation.
So one donor advised fund, right? Client was giving significant amounts of money to the temple, right?
Right.
And he set up the donor advised fund with a schedule, right, to basically fulfill what he was doing, and he ended up increasing his tax efficiency, saving money on taxes. And you get to direct it. You just send an email. I want to go ahead and send this much here, this much here. One client wanted science, engineering, and math and technology, education, charities for kids.
I do want to cover charitable trust for a second, because if you start a charitable trust, and there's two kinds, but I think the remainder trust is really interesting because it takes the money that you put in there out of your estate. You can take this, or you can take the income generated in it can go to a charity, and then the balance at the end goes to your heirs. And so, from an estate planning perspective, that does a couple of great things, right? You get the tax deduction. The charity gets the income. The corpus goes to your heirs, however you want that split out. And it takes out of your estate for estate tax purposes, and that's really good for higher net worth clients.
Now, pre-gifting, I've got a client that's filing a 709 this year, right?
Okay, yeah.
Gifting to the two kids, right?
I have a couple of those cases too.
Yeah, the 709 says I got a 15 million exemption lifetime, but I'm taking whatever I just gave that's over the gifting limit for this year, and I'm reducing my 15 million. You have helped preserve the spousal exemption.
Yeah.
So one spouse passes away, 15 million is a lot higher than it used to be. And how do you lock it in?
That's right. You file a 706. It's the unused spousal exemption. So, but I'll just give you an example. In my family, my father passed away. This was before some of the tax laws were made permanent. We filed a 706 so my mom could have the 15 million as part of her exemption as well. So it preserves it, it grandfathers it into the tax rule. So if they change tax rules down the road, it is grandfathered. You're not going to lose it. But you only have 90 to 120 days to file it, or you lose it, right? So you had 30, you waited too long, now you just have 15. They changed the tax laws in 10 years.
And
down to 5,
down to 1,
down to 5 or 1, and so your heirs are now stuck with a huge estate tax bill. So that, I think that's really something that a lot of people don't take advantage of. Really thinking, well, I don't have enough to do it, or I'm under the threshold. We're at 25 million. Why should I do that? That's why you would do that.
Oh, because you preserved what is a relatively large current level.
Yeah.
All right, now this. Well, I want to cover your ladybird deed. This is something that you mentioned. It's a Texas thing.
Yeah, there's a few states that have this. It's basically a transfer on death form for your house. So we have a client says, hey, yes, we have some assets, but it's a pretty simple structure, right? We have IRAs that are going to our kids. We have a TOD on our joint account that's going to our kids. We have
what about the house?
On our banks, we have that too. What about the house? Well, in the state of Texas, you can file a transfer on death deed, and it's very simple, just like you would have a POD or a TOD on any other account. Upon death of the two spouses, that'll pass directly to the kids. And you got to take that down to the courthouse, and then upon death, there's an affidavit you got to sign. But it's fairly simple, and it keeps it out of probate.
All right, coordination with the CPA, right? And current deductions, tax liabilities in the future.
So one of the things that I've seen also is when a spouse passes away and you got the big house and you live there forever, go get an appraisal because you get a step up in basis on that house.
Oh,
That's right.
and you want to have it in writing.
And you want to have it in writing on that date of death and the other assets also, right? So that's a coordination with us and the CPAs to make sure that you get the best tax advantage possible in that scenario.
All right. Oh, remember when we drafted this originally, they were saying, we could lower the estate tax exemptions. That's a political danger.
That's right.
Yeah, but we won't get political, but we would say it's a future danger. Now, family limited partnerships, and there are also family corporations, but go ahead.
Yeah, the family limited partnerships are still used. You used to be able to sell part of it to one of your kids at a minority discount. And so those rules have changed a little bit, but they're still worthwhile. You can gift so if you put some land or something like that's what we've seen into the family limited partnership, you put some funding in it. You gift part of the FLP to your kids every year as part of your gifting strategy, or you do it through a 709.
Oil royalties, ranches, the King Ranch is a great example.
Yeah.
800,000 acres. He said, don't ever sell an inch.
Yeah.
And it still operates today. It's a corporation, and the setup of that partnership corporation had in it who gets to be in charge, who's eligible, who owns,
right,
and how it goes through the generations. So the King Ranch is a dynasty.
Yeah.
I mean, it never ends, and they had a very clear succession plan, which also allows the family to throw out the ne'er-do-wells.
That's important. 'Cause I've seen it where you can't throw them out, and it's a smaller ranch land piece, it got nasty for a while.
To prevent that, that's part of your wealth manager's role, is to get in there and prevent the future squabbles.
Yeah.
Or if they happen, we've had a lot of squabbles.
We've had a few.
Yeah, there's a lot of squabbles. And how do you preempt that? Your wealth manager taking the initiative to coordinate with each of the beneficiaries and diffuse their selfish infighting.
There's something else I've seen also. There's a trustee. It's a family trust. Parents died. He became the trustee of the next trust that got created out of this. And there started to be some infighting. And so he said, well, I'm naming him corporate trustee. I'm out.
Oh.
So now you guys have to deal with the corporate trustee, and good luck. So that works too.
Well, we had a crazy lady foisted on us by a trustee once.
Oh yes, we did.
Yeah, we have since raised the minimum wealth standard for our wealth management team. But he felt really lucky on the day that he was able to foist that lady on us.
Yeah.
But anyway, we're just saying, you really want an experienced team that works together with the processing execution abilities, but also the ability to take the initiative, coordinate with the beneficiaries, help with the other pieces of the estate, even if they're not custody.
So I want to say this. What are the 5 things that you can do right now?
This summer. It's summer planning season.
So update your beneficiaries. First thing you can do. You can go through all the things that have beneficiaries, all the ones that don't, and make sure they look like you want them to.
Yeah, we call them up on a Zoom call, so you can see them.
Then, if you don't have a will, you should probably do that. And then you can kind of talk about, well, do I want a will or living trust? But you do need to get something in place. Right now is a good time to be talking about that.
And make sure your wealth manager's got a copy.
Yeah,
If
absolutely.
they don't have it in their document vault, you've missed a key step. Now, this one could be dangerous.
Well, digital keys, all your passwords.
Be careful.
Yep.
Yeah,
put that on. You got to put that on a drive and put it in your safe, but know that somebody can actually get in the safe, right? If they need to get it. But that has your passwords.
Or your wealth manager could have it just in case.
Yep.
For the future.
In your will, make sure you're defining fairness. You don't want squabbles over the kitchen table that's been sitting there for 40 years. And then have the conversation with the kids and say, hey, here's what we want. and here's how we want to do it.
Yeah, my aunt said that my sister gets all the jewelry, my brother gets all the furniture, and
Well, what do you get?
I get to be the executor
You
and
get
do
the
all the work.
You get the responsibility. Congratulations.
Like, well, okay, that's fine with me. But the conversation is important, and we've actually had clients that have done videos
Oh yeah.
that said, here's what I'm doing, and here's the way I want this to go. Now, that didn't prevent bad behavior. It doesn't always prevent bad behavior,
Yeah.
but it's close to it. And so this is a process. This isn't something you do once. And a lot of people haven't even read their will.
No.
So we actually call it up on the screen in a Zoom call, go over it and make sure we understand. And the client, a lot of times, has forgotten what's in there and they have to do an amendment.
Or there's somebody in there they don't want in there anymore.
Yeah.
I've seen that too.
What's that?
So-and-so doesn't get anything. Give him $1.
Yeah. You give them $1 just to make sure that they're like, hey, he forgot because he was old.
Yeah.
You're like, no, here's my videos explaining all your bad behavior that caused that poor, that situation. All right. And here, this is the team you want on your side. You can email us, info@themcgowangroup.com. And you can do an old school telephone call, because at McGowan Group Wealth Management, we actually answer the phone. And Preston Lane, our ambassador, if you're lucky enough to get Preston, he knows how to get you to the right spot. So we look forward to serving you and your family in the decades ahead and making sure that when you're gone, there's no trouble. Thank you for tuning in today to Net Worth Media. We also have Apple Podcast. Simply type in Net Worth Radio and boom, it'll hit your phone right then. If you also go to networthradio.com on a browser, you're going to be able to meet the team. You can see our performance track record, the model portfolios that go with today's broadcast. Also at networthradio.com, the Longer Play podcast is available there as well. We're grateful that you've tuned in. Remember, when we talk about a security, it doesn't make it a recommendation for your portfolio until we actually complete a written plan for you by Zoom or in office or simply a conference call. So you reach us at networthradio.com if you want to get that arranged. Market fluctuations and how to handle them. We build high cash flow portfolios, and past performance doesn't guarantee future results, so you do have to be ready for challenging markets. We can build more cash flow during challenging markets than we can when everybody's happy and everything's up, which is when we tend to raise tactical safety. Those allocation strategies are here at networthradio.com. Thank you for tuning in.